Test. 1, 2. Hi, everyone. I hope you had a very nice networking lunch. We are super pleased to have you today and to welcome you at Accuracy for this panel on litigating sustainability. So, of course, the panel will get into it in a few minutes, but first, we wanted to introduce a bit the topic with a keynote on the trends and the different types of ESG disputes. And hopefully, by the end of this keynote, you'll be able to know what a farmer in Peru, Dutch activists, and McDonald's all have in common. So it's not lost upon you that there's been a lot of ESG disputes in the past years, and those disputes take several forms. It can be dispute around the duty of care, it can be environmental lawsuits, it can be greenwashing claims, we can talk about human rights violations, so really different matters all included in ESG disputes. Those disputes have been increasing, as you can see there, and it's the environmental litigation have been really expanding in the US, but also globally. And we see exactly the same trend in France for the duty of care and all the lawsuits around this type of disputes. So why are those ESG disputes increasing? Several factors. The first one, the regulatory framework, of course, and it's not lost upon you that France here has implemented the duty of care in 2017. But also other factors, new stakeholders that are applying pressure, whether it's the NGOs or investors or even the courts. So let's zoom in a bit as we're in Paris with the French duty of vigilance and all the lawsuits. So what happened there is that there's been an increase, of course, of lawsuits relating to the duty of care, and companies that are summoned for different topics. So we can see here, for instance, the group Casino has been summoned for alleged deforestation and human rights violation in Brazil. McDonald's, on the other hand, has received a notice for a failure to implement its vigilance plan. And the last one we had is Orano and EDF, last example, of course. And for them, they received a formal notice due to their activity in Russia and alleged human rights abuse in Russia. And the court already in 2023 has gave out 2 verdicts already on those type of new litigation. The second one that we see here against Total, so Total in relation with their activity in Africa with the ICOP and Tilenga projects, the French court dismissed this case based on inadequate court procedures, in their opinion. And the second one was La Poste. And La Poste, the court required them, so there was a true verdict, and they required them to implement a risk management and really implement and commit to a strict risk assessment process. There were no fines, so no real financial penalties for La Poste, but reputational, of course, consequences arise. So based on all of this and those cases, we can see that courts are more and more willing to challenge big companies, but we can see that in terms of financial penalties, we're not there yet, and the results are a bit mixed. If we zoom out, so globally, what has been happening, and here I'm going to give out 3 cases that reflect well, I think, on ESG disputes. The first one, maybe I'm not clicking. Yeah, first one relates to Shell, the oil and gas company, that was sued in the Netherlands by NGOs. And here the NGOs were saying that Shell did not respect its commitment towards climate and towards net zero. And what's interesting is that the courts have ruled in favor of the NGOs by saying that Shell had to commit to its net zero commitment or to its climate commitment. But the court said and returned a bit on the appeal and said that they were not in a position to be able to say to Shell, okay, you have to reduce by X% your greenhouse gas emission. But however, it was a first to say that they had to commit to their net zero emission. Another case, here we're in Peru, where a farmer has sued NWE, so the German energy company, saying that this company has an alleged responsibility in global warming, and global warming led to the melting of glacier in Peru that led to flooding that impacted his house. And what's interesting here is that for the first time, the court has decided to pursue and to look into it. And so now they are in evidentiary phase for this litigation. And it's really a first. And what does it mean? It means that private company now could be held liable for damage relating to climate change. And one last case, still going back to the Netherlands. Here it's the other way around. So ExxonMobil and Shell have sued the government in the Netherlands because they asked them to stop exploiting their gas field in the Netherlands earlier than expected and agreed, leading, of course, to financial consequences. So they led an arbitration proceeding against the Netherlands. And here this case, I think, is interesting because it also reflects on the fact that sometimes regulation towards the fight against global warming can lead to imbalance with investor protections. So to try to break down a bit all those environmental litigation that are numerous and different by nature, we have segmented them in 5 main types of disputes. The first one is contractual breach. I'm sure you're aware of those, and we can think maybe of dispute on technical parameter for a wind farm, for instance. The second type is pollution. So when a pollution event happens, this one is pretty straightforward as well. A third type of dispute arising are all the disputes relating to damages due to climate change. And here we can find the Peruvian farmer in this category. A fourth category of environmental disputes are all the greenwashing related claims. So when companies are sued because they have to enforce or accelerate on climate policy, companies and governments, of course. And here that's the first cases we saw where NGOs sued Shell. And the last category of environmental disputes are all the disputes relating to new regulation, where here it can be states vs investors. And it's the last case where the Netherlands were sued by Exxon and Shell. I'll conclude on this short keynote with a few themes. The first one, you saw it, ESG disputes are very different in nature and they are complex. Complex because they are most often happening on a cross-border, which means multiple jurisdictions involved. They are complex by nature also because the causal links are difficult to assess And most of the time, because you need expertise from multi experts, whether scientific, financial, technical experts. So it's challenging for the courts to proceed on those ESG disputes. Sometimes they don't have the time, sometimes they don't have the expertise. And I leave you with that on the role of arbitration, whether or not arbitration can be a viable mechanism to address those kind of ESG disputes. And I'm sure the panel just behind me will have a lot to talk about on this. Thank you very much.
Thank you, Julie, for your presentation and for your conclusion, which lead us right into the topics we will be now discussing with our panelists. Today with us we have Sarah. Good afternoon, Sarah.
Good afternoon.
You are partner at 20 Rue Avocats, advising clients on environmental law, including crisis management, environmental liability, and regulatory compliance. You also support companies with a sustainability reporting obligation as a duty of vigilance and CSRD. Michel, good afternoon. You are partner at Jones Day in London, and you are leading international arbitration. You are a leading international arbitration lawyer, increasingly involved in ESG-related matters. You have experience in representing states and private entities on a wide array of matters, including investment arbitration, commercial arbitration, and climate and human rights matters for corporates. And our third panelist is Lawrence. Good afternoon, Lawrence. You are managing associate at Mishcon Purpose in London. Your practice focuses on ESG-related litigation, arbitration, and also advisory works. You are involved on strategic claims such as greenwashing, climate change, environmental harms, representing NGO, businesses, and individuals. So thanks a lot to the three of you for being with us today to discuss this interesting topic. So the first part of our discussion will be dedicated to, in the continuation of what was said by Julie, describing the current landscape, what happened, particularly in France, in the UK. And we will start with the topic of the duty of vigilance. We have seen the figure, the number of disputes is growing, so it's a relevant topic to address today when we speak about dispute resolution process. And we will take the advantage of presence of both French and English lawyers in order to focus on the contrast between what happened in both countries. Sarah, if you would like to start by giving us by your view, your experience on the impact today in France of the duty of vigilance law on the business operation of our companies.
Sure. Thank you for this introduction, Julie. So the law on the duty of vigilance in France was implemented in 2017, and it was actually one of the first laws in the world implementing a duty of care in order to have a real accountability for corporations around environmental and human rights issues. So it was a big step forward, an important law in France for the corporations. But once we've said that, actually, if we want to look at the impact of this law in the day-to-day operations, I would say that is not that big for several reasons that I will present. First of all, the duty of vigilance in France only concerns huge corporations, meaning corporations having more than 5,000 employees in France or more than 10,000 worldwide. So at the end of the day, the number of companies actually concerned by this duty of vigilance is very limited. We don't have the figures, but it's around 270 to 300 companies who actually have to implement a duty of vigilance plan, which is obviously a limited number of companies. The other thing is that well, on this issue, it should be noted that not all the companies which are actually supposed to have drafted a plan did it. And the NGOs are the one who actually monitor the existence of the plan and who look at the risk that are in the plan. And the NGOs, and actually it's interesting to see that the NGOs have a special website where they look at the vigilance plan of all the companies, which is called in French Radar de la Vigilance, and which is very interesting to look at if you're a company and you want to see what the NGOs look at. They only focus on important sectors. The sectors are retail fashion, extractive industry energy, agriculture and food, and the financial sector. The other sectors, the NGOs are not really looking at their vigilance plans. So to answer your question, the impact on the operation for all the other companies which are concerned, it's not that monitored by the NGOs. Another point which must be discussed for the French law is the wording of the law is quite broad, meaning that we don't really have a precise vision in the law of what is the duty of vigilance in France, and so the companies are really supposed themselves to decide how far they go. And in terms of impact, it depends on what the company want to do and what want to say. And for example, Total Energy considered that the law only focused on environment, and so the first plan of Total Energy did not tackle the climate change issue because they considered that environment is not climate change. And from a purely judicial point of view, it's true. So it means that for the day-to-day operation, it's not a huge change. And what changed the last couple of years is the existence of the project of directive on due diligence, because this directive, the European directive, actually went a lot further than what the law, the French law did, and all the companies decided to tackle the issue with this European movement. But as you probably know, there is a strong movement nowadays try to reduce the scope of the due diligence, which is called the omnibus proposal, and which changes a little the aspects of what the companies want to do on this issue.
Okay, thank you, Sarah. This is for the duty of vigilance. And if we try to have a look to a wider spectrum of the ESG-related issue, we have sometimes a link between the duty of vigilance and some environmental dispute. And sometimes I understood, Sarah, when we prepare this intervention, it comes from the gap you can have between the voluntary statements of the companies and the mandatory reporting, typically for the greenwashing claim. Do you have some experience with this type of dispute as well?
Yes. I think yes, of course. I actually counsel many companies on how to communicate on environmental issues. And it's a big challenge for corporations in France, because on the one hand, you have the obligation to communicate on your environmental impacts. First, if you are subject to due diligence plan, because you have to draft in a part in the plan which say what you do for the environment, what are the risks related to your activity for the environment and for human rights. Also, you are in a world where you have a lot of competitors who all say that they are neutral, in carbon neutral, they offset their emissions, and so you have to also position yourself in saying that you are neutral and you do a lot for the environment and for the human rights. So, and if you don't do it, then you could be attacked by NGOs, for example, because you did not enough write your vigilance plan and you did not go far enough on tackle the risk of your activities on the environment. And on the other hand, we have in France a very strong framework on the green claims, the sanction of green claims which are ungrounded. And so the companies are in the challenge to navigate between, on the one side, the fact that they have to communicate on the environmental issues, and on the other hand, they have to be very careful on what they communicate about, because they could be attacked on many grounds in relation to misleading information based on their environmental communication. And so it's a complicated position to have for companies on how to communicate, what is mandatory and what is voluntary, and which could be a little narrowed, but you are in a world where you have to tackle all these issues at once. So yes, and we have two case law on this issue. The first one is Samsung. They wrote on their website a little sentence saying that they would be one of the most ethical company in the world. And unfortunately, an NGO produced, just after this sentence on their website, a report on child work at one of their contractors. So there is a proceeding because they lied in this sentence on their website. Another case law important in France, it's Total Energy. They branded all their communication saying that they would tackle the idea of crisis, climate crisis, and NGOs attacked this communication, saying that it was not truthful, and it's two litigation that are ongoing, but that show that the companies cannot say whatever they want on environmental communication.
Thank you, Sarah. So we can move now to what's happening in the UK with you, Lawrence. Do you agree that the ESG litigation is being driven by new regulations?
Thank you, Guillaume. I'll perhaps just take half a step back from that question, if I may, and just sort of think about the policy space in general as it concerns the sort of multiple crises that we're facing. There's, just to take one of those sub-crises, which is the climate, we know that the nationally determined contributions that each state has pledged under the Paris Agreement add up to commitments to keep the world on track for warming of 2.7 degrees. It is far short of the 1.5 degree warming limit that is considered safe under the best available science. So there is a huge gap between where policy is at the moment, where regulations are, and where we need to be. And that gap has been tried to be bridged by strategic litigation, by the courts. And so to answer your question head on, the regulations have been important, like in France, but they've been too little and too late. And so there's been actually a lot of success in going down the litigation route to try and drive up those commitments and those obligations by using general legal principles, which are not specifically designed for the climate crisis or the ecological crisis. And there's an important dynamic here that I want to point out between what's happening in international law and what's happening in domestic law. A lot of the strategic cases, particularly the early ones, were what we call government framework cases. So they were proceedings launched notably by NGOs, by associations on behalf of citizens against their own governments to clarify government's obligations under international human rights instruments, notably. And a key case there is the Uganda case in the Netherlands, where in 2020 that went all the way up to the Supreme Court, and the Supreme Court held that indeed climate change was a human rights issue, and that states that did not take adequate action were in violation of Articles 2 and 8 of the European Convention, right to life and right to private and family life. And as a result, the court ordered the state to reduce national emissions by 20%. So that was sort of the background for civil cases that followed on. The Milieu Defensi case that Julie mentioned in the outset was only really possible because of that precedent by the Supreme Court in Uganda. Now, in the Milieu Defensi case, again, regulation was not the issue. The issue was, can Dutch principles of tort law, the Dutch standard of care, which is in the Dutch Civil Code, it's expressed as an unwritten rule of conduct, can that open standard be used to impose obligations on corporations to reduce their emissions? That was the question to the court. And the answer was clear. The answer was yes. There is now an established recognition that, one, climate change is a human rights issue, and two, big corporations can be expected to respect human rights. That was the key finding of that decision. And what was very interesting and very important there was that Shell itself had held itself out as complying with soft law instruments on human rights, the UN guidelines and the OECD guidelines, which now, interestingly, are incorporated into the CS3D. So regulation came later of trying to make those soft law instruments hard law. So actually, the strategic litigation was ahead of the curve. Now, in the UK, there's a similar situation where our regulations are terrible and toothless. So in terms of the duty of vigilance or the due diligence obligations that companies have in relation to the supply chain, we have the Modern Slavery Act of 2015, which was pretty groundbreaking at the time, but that was 10 years ago. And there is no enforcement mechanism under the transparency provisions. Of course, if a person who is found to hold another person in slavery, of course that's a criminal offence and it's sanctionable under criminal law. But in terms of the supply chain and the obligation on companies to investigate their supply chain and prevent modern slavery, there is no criminal sanction and there is no civil enforcement. Now, interestingly, the CS3D in the EU did have a civil enforcement regime in its original form, but that is now likely to be repealed under the omnibus, as Julie was saying as well. So there's a real civil enforcement issue there. Now back to the UK, we don't have strong laws. Therefore, litigators have tried to resort to the common law, good old-fashioned common law negligence, and have been extremely successful in building up a body of case law over the last 20 years, which holds very clearly that corporations can be liable in negligence for actions of their subsidiaries or actions even of their suppliers. And a key case that I want to reference there, of course, is the Vedanta case, which is a Supreme Court authority from 2019. Now, that case was about Vedanta, UK registered company that operated a subsidiary in Zambia, which operated a copper mine. And an action was brought in England by about 2,000 Zambians who lived near the mine, who claimed that the mine wastewater had polluted the waterways and was causing personal injury and property damage to them. And the Vedanta parties resisted jurisdiction on the basis that there was no case to answer for the English company because there was no duty of care owed by the English company in relation to the Zambians. And it went all the way up to the Supreme Court, and the Supreme Court said that was a arguable issue. and it had to go to trial. So we don't have a full merits judgment yet. Vedanta subsequently settled, so we don't know yet how that would have played out, but we do know as a legal matter, that preliminary issue, is it possible to owe a duty of care to people affected by your subsidiaries? The answer is yes, under English law. And now that principle has been extended recently. Just as recently as last December, there was an important judgment by the Court of Appeal in a case brought against Dyson, the vacuum cleaners, the hand dryers, in the UK, by a number of individuals who were Nepalese nationals who worked in a factory not owned by Dyson in Malaysia. And that factory was supplying Dyson with parts. And they argued on the same basis that Dyson in the UK owed them a duty of care. And again, it went up to the Supreme Court, the Court of Appeal, and the Court of Appeal held last December that was indeed possible. Now, the legal test of when a parent company could owe such a duty is there has to be a very high level of supervision and control. Now, that's a question of fact, whether that's actually the case. And what also matters is not the actual level of supervision and control, but also if a company holds itself out as exercising that level of control. If you say in your CSR brochures, we know all of our suppliers, we check them, we investigate them, we regularly monitor them, we hold them to account to comply with our CSR policies. If you say that, then you're likely to owe a duty of care. You're likely to be held to your word. So, in summary then, the duty of care does not depend on regulations. However, if there are regulations that will require companies to exercise greater due diligence in their supply chains, such as the CS3D, which will apply to a number of UK companies, then it's more likely then, as a result of that you will owe a duty of care, because you are exercising more supervision, you are exercising more control, because you have to under the CSRD and the CS3D. So there's an interaction there between the common law and regulation, which will play out over the next few years.
Thank you, Laurence. To close this first section, Michel, would you add anything on what's happening in the UK or maybe more under the international law?
Certainly. So I completely agree with what Lawrence was saying, but I think I'm slightly more sceptical in terms of what the UK law actually offers. Clearly, we don't have any regulation. There have been attempts to put forward into Parliament a bill quite similar to the EU directives, but that failed. And in terms of the common law offering a potential solution to this, whilst there's been a number of cases which will now go to trial or may go to trial, the question is whether they'll actually succeed. And there's a lot of scepticism as to whether that will actually go through and there'll be a finding that this type of behaviour will, for example, amount to a breach of a tort. But what is actually quite interesting is through that process, there is a significant amount of disclosure required. And so that really does come down to what are corporates saying in their board meetings, etc. And I think that is a considerable risk, which is actually changing behaviour. So even if it doesn't progress to a finding that indeed there has been a breach, I think that there's many corporates who, for example, we're advising as to how their practices should alter in light of this. But just going back to the international level, because we've heard about the UK, we've heard about France, but all of these, the concept of supply chain, due diligence and reporting actually stems from international law. So we've all, I'm sure, heard of the UN guiding principles. And they were really targeted at creating change. So Sarah's mentioned that, and I was quite interested in your comment that the duty of vigilance doesn't really have much impact, because we in the UK, I'm sure Lawrence, you're the same, we point to France as actually having this law that makes a real impact. But the rationale for the UN guiding principles was, if you take the globally 100 entities, states and companies that are the wealthiest, 69 of them are non-state entities, so corporates. And it really was trying to affect change. If you could change 100 entities, how would you do that? Traditionally, the system had always been on states. So states signing up to treaties, whether they were relating to climate change, whether they were relating to human rights. Whereas there was a real shift to actually, let's focus on corporates, and that will deliver the change we actually need to see. So that really happened through the UN. It happened through a body within the UN known as the Human Rights Council. The Human Rights Council has a number of special rapporteurs and working groups that are really focusing on corporates, their obligations to in relation to climate change, and their obligations in relation to the United Nations. So there's two advisory opinions with ITLOS, which is the International Tribunal of the Law of the Sea. Now, it issued an advisory opinion looking at what the state's obligations were in relation to the law of the sea. Now, that advisory opinion is not binding, but it actually comes down quite firmly on climate change and takes the state's obligations further than what many commentators and lawyers anticipated. Presently, before the International Court of Justice, we have an advisory opinion which has asked the judges of the court to opine upon what a state's obligation is in relation to climate change. So hundreds of submissions have been made to the ICJ. Hearings have actually taken place. But a number of countries have put forward very different views. So there's the view that climate change is governed by a set of principles and law which is completely isolated to the law pertaining to human rights. Whereas you can imagine a lot of states and bodies are actually saying, well, there's these overlapping obligations on states. So that decision is likely to come out at the end of the year. And that will obviously it won't bind anybody, but it'll be exceptionally influential on states, and no doubt will be used by NGOs and other entities to really lobby for change. The other key area of international law, which we've touched upon quite briefly, is investor-state arbitration. And that is where companies can sue states under international treaties for a breach of those set obligations in the specific agreement. Now, I've been speaking about this topic for nearly a decade, that I think that there is this huge issue coming because states have now conflicting obligations under some of these treaties. Obviously, there's a network of about 3,000 of these treaties. They all differ, but the first generation treaties are exceptionally broad. And they say that they will do certain things to protect investors. I think there is a real conflict in these obligations, and I effectively think that states are damned if they do and damned if they don't in terms of climate change. Because if they regulate in relation to protect the environment, like we've seen the Netherlands, so they were sued in their Supreme Court, the government decided to do more, it chose to phase out coal power plants by 2030. As a result, a number of companies who had invested into the state in coal power said, hang on, you're breaching these treaty obligations. And so that was RWE and Uniper. They have settled for different issues, but it was under the Energy Charter Treaty. And so they were saying, well, hang on, we're meant to operate our power plants to 2050, 2060. If you're cutting that down to 2030, that is a huge loss for us. So I think that this is a space where if states regulate in accordance with their Paris Agreement obligations, they will be subject to being sued by companies for breaching different international law obligations that they've seen. So I think that this is an area which will create great tension as we move forward.
Thank you, Michelle. It's now time to move on the second part of our discussion about some court decision and the reputational impact. You already started to discuss this point. We can start coming back to France. Sarah, if you can maybe give us some insights about the new jurisdiction we have in France in order to deal with what we call the emerging topic, emerging disputes, and if you have already some examples of judgments that have been issued.
Yes. So in France, we have a double movement of new litigation. We have for environmental issues a more and more criminalization of those issues. When I started to work 12 years ago on environmental issues, the pollution litigation, they were always dealt with directly between the companies and with the local authorities in charge of the environment. And there were always there were never criminal cases apart from huge pollutions like sea pollution. But for small pollution or small environmental cases, it was all civil justice or directly dealt with the authorities. Now it has changed a lot because even for small pollution, it will go to criminal trial. So it's a huge change that began, I would say, 5 years ago, and which really was increased by the law which is called Climat and Résilience in French, on climate, which increased the amount of sanctions related to damages to the environment. So that's the first movement, the criminalization of the damages to the environment. And the second movement is what we discussed just now, this new emerging litigation about the duty of care, about greenwashing, and based in France on regulations that exist and that request the companies to do more about their environmental impacts on all their value chain. And in order to tackle these two new issues, it was decided to create a new chamber in the Paris Tribunal, which began its work. And why was this new chamber created? Of course, for reason of specialization of the prosecutors and the judges. Because for environmental issues, it's mainly very technical issues, and we see when we are a lawyer for companies like me that we sometimes have judges who have no idea what is a pollution, no idea how technically it's dealt with, and we had big discrepancy between attorneys of big corporations who would be very used to this kind of litigation and judges and prosecutors who would not. And so they created this chamber which is specialized in these emerging issues and who know what is greenwashing and how pollution works. We had a first, I'm not going to talk too much about it because Julie did it already, the La Poste case, which is on the duty of care, the French duty of care, the first time that the judges went to judge on the merit of the case, because all the other cases just stopped at the proceedings stage or are ongoing. So in the next years and next month, we will have other decisions on the duty of care. But for now, we have the La Poste one, which is an interesting one, because I was talking earlier about the fact that the wording of the duty of care law in France was very broad, and the judges they do not want to go further than what the text say, and so they are a little limited by the text. And I think this La Poste decision is an illustration of that. They said that the plan was not exactly sufficient, but they did not want to go to financial sanction. Another thing which is very interesting in France, it's on the judicial way of dealing with ESG cases, are what we call the CEGIP. So it's kind of plea guilty for corporations on environmental issues. It existed for corruption issues since a long time, and it now exists for environmental issues. And we've had, I think, 20 or 30 CEGIP on environmental issues recently. But what is interesting is that for corruption, we have 7 billion euros fines for 9 CEGIP. In environment, we have CEGIP around 5,000 euros for an environmental damage. So we are really, really far away on financial sanctions, and that is one of the issue which is challenged by NGOs, saying that, first of all, the CEGIP, it's kind of a negotiated justice, so it's a little scary because we don't really know what is discussed between the big corporation who polluted and the prosecutors, and that is not really well seen by some people and NGO and the civil society. And the second issue, which is obviously true, is that the sanction, the financial sanctions are really low in comparison to what it could be, because the sanctions in France for criminal environmental damages could be high, but actually it never happened. So that's the framework in France.
Understood for the France. Thank you, Sarah. Lawrence, do you want to comment on, to give your opinion on the rulings already issued in the UK? Do you share the view on what happened in France?
Thanks, Guillaume. Yeah, I do. I should speak more softly. I'm obviously, quite passionate about this topic. So in terms of the interplay between judgments we see coming out of the courts or regulators' decisions and public pressure, the pressure on reputation, I think as a theory of change, reputation is a very weak theory of change. I think it can work in sectors where you have a target audience that specifically wants to choose a sustainable lifestyle, right? That target audience will be susceptible to decisions that expose greenwashing, for example. And I think one community there is the investor community, which is very important. So I can't point to any decisions yet, but I can point to a complaint made actually in France by Client Earth against BlackRock, a complaint that was filed with the AMF, the French financial markets regulator, which essentially held that a number of BlackRock's sustainability-themed funds actually held very large holdings in carbon majors, so that this was misleading the investor and that this was greenwashing. And the AMF has not yet issued a ruling on that, but very interestingly, BlackRock has already renamed the majority of those funds. So that was an effective complaint in that sense, even without needing to get a decision by the regulator. And that only works in sectors that are sensitive to that kind of pressure. Now, if you look at oil and gas majors, their whole business model is based on producing as much oil and gas as they can for as long as they can. And that sector does not seem to be susceptible at all to reputational damage. In fact, that sector's come out swinging against ESG litigation, and there's now a whole movement of a backlash of where, for example, Shell has sued Greenpeace in the English courts for occupying or trying to occupy an offshore oil platform in the North Sea, and they sued Greenpeace for substantial damages. That has now settled. Or ExxonMobil, of course, is suing some of its activist investors in the States. Greenpeace is also facing an existential threat in the States in the North Dakota pipeline dispute, where the pipeline operators are now suing Greenpeace for damages for service interruptions caused by the protests, supposedly. So that sector is absolutely not going to budge due to reputational reasons. And the reason is clear, because that sector essentially has almost like a sort of monopoly power. The consumer doesn't have options often to choose where it gets its oil-based products from. Oil-based products are in textiles, in cosmetics, in everything that we don't even see. So for that sector, I think going for damages awards and increasing the financial stakes for these businesses is a better theory of change. And now in the UK, there are no decisions yet to point to, but I would say there's one very important one which has just completed its preliminary trial, so its preliminary issues, which is the Mariana Dam case, which some of you might have heard of. It's actually the biggest group action that's ever been in the English courts. This is an action brought by almost 750,000, 750,000 individuals and businesses in Brazil, including some public authorities, against BHP Billiton, the mining conglomerate, for an iron ore mine dam in Brazil that collapsed and released a huge amount of wastewater downstream and polluted riverways downstream. Now, the claim value of that claim is £36 billion, which is, an extremely, anybody who's been in arbitration, if you ever see £1 billion or $1 billion claim, your eyes water. But 36 billion, you can imagine every stone is being turned over in that case. And that was one of the cases where the UK courts, where jurisdiction was very, very fiercely resisted. And the English courts asserted jurisdiction in the end on the basis of the potential duty of care that I spoke about earlier. And it's now gone to full trial. The first issues on liability were tried earlier this year. So I would say watch this space. Perhaps Michelle's is a bit more skeptical, but I like to be optimistic.
We can hand over to Michelle. And Michelle, I think with you it's also important to speak about what happened outside the courtroom, because you wanted to comment on the fact that there are also equally important challenges, and particularly about the strategies implemented by the NGOs to affect the reputation of the targeted companies.
And it's quite interesting. I don't mean to disagree with you, Lawrence. However, I think that companies are, and from the insights we're getting from our clients, they are taking this issue seriously, even if it's not a litigation risk. So the reputational risk, actually, from what I'm seeing, is really driving some significant change. So it's driving internal policies, targets, modes of operations, etc. So even if there isn't that litigation recourse, I think there is that internal change that's happening within a number of companies, including fossil fuel companies. And I think that this is happening because NGOs, obviously we've got the framework that's changing quite considerably, but I think that NGOs are taking a really targeted approach towards some companies And are they doing that in a way that I don't think we would have seen 20 years ago, for example? They're exceptionally targeted, they're well funded, they have a very strategic vision for what they want to achieve. And it's occurring across multiple jurisdictions in various different ways. And so I think that we've obviously got litigation, which we've covered, but targeting companies through, for example, the United Nations, through what I referred to before as the Human Rights Council. Now, traditionally, the Human Rights Council would only focus on states, and so they would lobby states to adhere to their international law obligations. So I've got some stats here. Back in 2016, the Human Rights Council would only approach corporates in what they deemed to be these written communications in 1% of all communications that were issued. As of last year, that now exceeds 20%. So you can see that even the Human Rights Council is shifting away from targeting states to targeting corporates. And why is this? Often, for example, they get exceptionally comprehensive, evidence-backed submissions from NGOs. And it's not just, when we see something that's really comprehensive, it's not just one NGO. It will be multiple NGOs across multiple different jurisdictions that are all adding something in to a really comprehensive briefing paper. So just to give you an example, the Saudi Aramco was targeted by the Human Rights Council. Why did it target Saudi? Obviously, Saudi Aramco, obviously for number of reasons in relation to their climate change, in relation to their policies, which were either consistent or not consistent with the Paris Agreement. But not only did they do that, it was on the back of a very comprehensive submission that they'd received from Client Earth. That was hundreds of pages. So that obviously gives them the ammunition that they actually need. Not only did they provide a written communication to Aramco, they also did it to 14 of their largest financial institutions that obviously lent money to them. And this is a completely voluntary process. Of those banks that were targeted, 50% responded. All of this is publicly available. And so I know for a fact that not only did the banks take it very seriously in terms of their response, but also companies that had contracts with Aramco took it quite seriously. So whilst there wasn't any direct legal risk associated with it, it was that indirect risk. And we've seen like a number of pension funds will step away from actually investing in companies that are being targeted by NGOs, that are being targeted by the UN. So I think that indirect reputational risk is quite considerable. We've also seen that with OECD proceedings. So that provides a mechanism for voluntary complaint as well. And so since 2020, there's been roughly 110 of these initiated against really large corporates. So I think that that is another way where this reputational risk can be quite considerable, whether the company chooses to engage or doesn't. So I think that this is definitely an area which is creating change.
Thank you, Michelle. Thank you. So now we have a better view of the current status, your current resolution process in place and their limitation. Thank you for that. So we can move to the last part of this discussion. And here now the question is to assess and your view on the fact that the arbitration could play a potential role in the resolution of this type of dispute and also a potential alternative dispute resolution processes. We can start with you, Lawrence. Based on the current status, what changes would you like to see in the future? And according to you, is arbitration a potential solution for the future?
Thanks, Guillaume. Well, I think arbitration can play a massively beneficial role, actually, and that's because arbitration, by its nature, is a hugely flexible tool and a transnational forum. Now, the cases that I was describing earlier regarding the duty of care, particularly the English ones, there's a structural problem that's common to all of those. And the problem is that you have claimant in one jurisdiction and defendant in another jurisdiction, right? So you have the corporate parent company that owes the duty in England, and you have the impacts, environmental and human rights impacts, occurring across the globe in different jurisdictions, and the claimants are there. Now, it's very difficult for those claimants to then access justice in England and to bring a claim in the English courts. It's possible, but it's extremely difficult, and jurisdiction has been resisted at every turn in these cases. So they've been lengthy and they've been costly, these proceedings. Now, arbitration can fix that with a stroke of the pen. You can give standing to your claimants as against your defendant through a simple contractual arbitration agreement. And that mechanism has been successfully piloted and used. And there's an important case study I'd like to refer you to, which is the so-called Bangladesh Accords of 2013. The backstory there is that Bangladesh, as you all will know, is a major hub for the garment industry. Huge numbers of garment factories there, supplying supply chains all over the world. The biggest buyer is H&M. Now, in 2013, a garment factory in Dhaka called Rana Plaza collapsed, killing over 1,000 people in tragic circumstances. And this was due to complete disregard of local building codes and health and safety. The first floor had been added to the building illegally, and essentially the vibrations that were caused by the air conditioning made the building collapse. And it was actually one very bad incident of a number of similar incidents. And so the industry really felt it had to act, and it within a matter of weeks after this incident, an agreement was signed between two global trade union federations and a number of Bangladeshi trade unions on the one hand, and on the other hand, the big buyers of textiles from Bangladesh, about 40 global brands and retailers. And the contract was a very simple one. It created a permanent secretariat in Amsterdam, which was responsible for carrying out and overseeing an inspection program of factories in Bangladesh. And the members of the Accords, so the buyer companies, they committed to require of their suppliers, so in their supply chain contracts, that those inspections are respected and that any findings for remedial action must be carried out. And then there's a disputes clause, which provides for a two-tier system. Disputes are first referred to a steering committee appointed by both parties, and decisions by the steering committee can then be appealed to an arbitral tribunal. And it's a very orthodox arbitration provision subject to the UNCITRAL rules, seated in The Hague and administered by the PCA. And it's been an enormous success story. So meanwhile, over 200 brands have joined the Accord. The Accord has been extended to Pakistan. It's now called the International Accord for Health and Safety in the Textile and Garment Industry. And literally thousands of factories have been inspected and remedial action has been taken. And there have been two arbitrations under the Accord, both administered by the PCA. And they were both brought by the unions as against the buying companies. And they went ahead, and in the end they settled. So we don't have awards, but the settlement shows that as a dispute resolution mechanism, there was a remedy, and there was a timely remedy. And the remedy in one of those cases is public, that the buying companies committed to paying about $2 million for the remediation of one of the factories that was non-compliant. So, in short, arbitration is uniquely suited, I believe, to bridging these structural gaps in supply chain disputes.
Thank you, Lawrence, for this example. Maybe now, Sarah. Sarah, do you think that it's relevant or natural to handle this type of matter, this emerging dispute, with arbitration? How is it is currently done with investment, commercial, or construction issues?
I think Julie described there are different kind of ESG litigation, and I don't think the answer can be the same for all these cases. I would say, I don't know, classical environmental cases like contractual provision on environment, post-M&A transaction with pollution issues, this kind of construction issues that lead to pollution, for instance, that, in my view, is really suited for arbitration because it enables a very technical expertise, and arbitration really enable to have experts, to have people who know how those technical issues work, and to have arbitrators too who understand those technical issues. So for this kind of litigation, my answer would be yes, obviously. And I worked several years ago on a big French arbitration on pollution matter after M&A transaction, and I think it worked because it was very technical. We had experts and we had arbitrators who understood this pollution issue. But my answer would not exactly be the same for all this duty of care litigation. I agree with what you just said, but maybe it's a French way of thinking. But just before, we discussed the fact that a lot of people criticized CEGIP. And CEGIP is not even confidential. CEGIP, it's an agreement between the prosecutor and the company, and it's a public. And then it's public, and the fine is public, and so it's not really a private justice, it's public. And it is criticized because it looks like a private negotiation that we don't understand really well, and the civil society is not included in such negotiation. And I feel that for duty of care, the civil society and the NGOs are really the main actors of this kind of litigation, as you mentioned. And so I'm not sure arbitration is the best way to include them, because what they want is to publicly explain what they obtain from the companies. And precisely, in my view, arbitration aims at confidentiality and not really explaining what happened during the arbitration. So that's a problem. But there is a very interesting case in France. It's only a month ago. We had the first mediation regarding the duty of care. It's a Danone case. NGOs attacked Danone on their vigilance plan. And as it always the case in France now, they went to trial, and the judges asked them if they would like to enter into a mediation process. And for the first time, the parties said yes. Well, it was not the first time the party tried, but it's the first time the parties actually succeeded in this mediation procedure. And it means that the NGOs on the one hand and the Danone, the big company, on the other hand, succeeded actually to find a way to deal with their litigation in another place than a trial. So I think it offers somewhat to go for arbitration, but they adapted the rules of mediation and the rule of confidentiality. And I think there is something to do for arbitration. If we want those cases to be in arbitration, I think we have to work on confidentiality aspects, because NGOs would probably not accept for all this private justice for all to be private, because they have people that ask them what happened. So that's my view on this issue.
Clear. Thank you, Sarah. Thank you for all this interesting example. And now I will give the last word of this panel to Michel to conclude. And based on your experience in arbitration in other domains, do you think it's relevant way to proceed for this emerging dispute?
What do you think I'm going to say? The opposite to Lawrence. I'm really conscious that I want to give you an opportunity to ask some questions, and we've already gone over time. So the key, I think it completely depends on the type of dispute. So I completely agree with Sarah's position that I think arbitration might be acceptable in some situations and not in others. But I think what we need is a system that appropriately deals with it. And I think that might vary depending on the actual circumstances. But I think the key features for me in terms of these type of disputes, one, transparency, which you don't really get with arbitration. Two, consistency in decision making. And I'm afraid that and it pains me to say this as an arbitrator, but in arbitrations you will often not get consistent decisions. And I think that really makes it complex for companies who are trying to operate within a framework, and they need certainty. I think there needs to be some form of appeal mechanism in the event that the law is just really inappropriately applied, which unfortunately sometimes we do see in arbitration as well. I think you need specialist knowledge, and with a lot of arbitration, whilst the mechanism is there in place to get arbitrators who do have a specialism in this, that is not always what happens. And I think you need enforceability. And so really for all of those key features, I don't know that arbitration is really that closely connected with those principles, unless you have a situation which is really quite bespoke, like the situation that Lawrence gave. But that was obviously after the event in order to deal with something. You would not get that type of scenario happening unless there's a huge amount of pressure on the said companies to do that. But I'm handing it over to you.
For your question, yes, of course. Thank you, Michel. Thank you, Sarah and Lawrence, for these comments. Maybe we can congratulate them. And yes, we are running short on time, but yes, I think it's very interesting to take your question, 2-3 questions, and then you will have the opportunity to continue the discussion with our panelists over a drink. Yes, please.
Eduardo Mayora from Guatemala and Central America. Well, thank you very much for a very interesting panel. I probably to Lawrence because of what Michel and Sarah have said, but in the Central American region, there are beginning but more and more thematic securities issues, including ESG issues. And I was wondering if you know of any cases where the bond issuer or the shares issuer has agreed to submit to arbitration if there were any claim that the company, the issuer has not complied with the promise that any particular goal, green or social or whatever, hasn't been met as promised to the investors.
Should I take it now? Yeah, okay. Thank you, sir, for that question. I'm not aware of any specific examples of that. I mean, generally with a bond issuance, right, you would have an agent acting on behalf of all the bondholders. And of course, there would be, it's possible because you would have a contractual relationship between the agent and the borrower. So it's perfectly conceivable that could be arbitrable. And I don't see any public policy reasons why it shouldn't be. In terms of the broader topic of sustainable themed bonds. This is a topic of huge scrutiny, and particularly by regulators. So I'm aware of one complaint made in relation to a Brazilian company, JBS, a big meat packing, meat processing firm in New York. In Washington actually, the SEC. A complaint was filed by a whistleblower, again with NGO assistance, and that issue is being investigated by the SEC, and has actually been taken up by the Attorney General of New York. Hence I misspoke, as an issue of securities fraud potentially, and the investment there is a bond of around 2 billion USD, several bonds actually, that were issued in 1 year close by, and they are sustainability-linked bonds. That means the coupon that the borrower has to pay depends on whether they meet certain sustainability targets or not. Now, the complaint focuses on the fact that those targets are de minimis, and they actually mislead by omission from the bigger picture that the business globally is responsible for huge amounts of greenhouse gas emissions and other environmental harms that are sort of left by the wayside, and so the investor who thinks they are actually promoting change in the business are being misled. So I would say this is going to be a hugely interesting area to follow in the next few years.
Thank you very much for those very interesting presentations. A couple of comments to rebound on what Lawrence and Michel said earlier in their presentations about what you said with the national contributions, the NDCs at 2.7 and distance with the Paris Agreement. There was a very interesting piece last week, I think in The Guardian, and that was translated in France by Les Echos, for those who are interested, by one of the board members of Allianz, the German insurance company, that says basically that at 2.7 degrees, most insurance will be gone. So risks cannot be transferred to insurers anymore. Risks may not be absorbed because the states or governments will not be able to have the public capacity to absorb those risks. And mitigation of the risk by adaptation will be very limited because basically if you overcome a certain number of physical limits, there's no adapting to mega typhoons, mega floods, mega wildfires. It's gone, and there's no insurance. So this is the very long prospect, but 20, 30, 40, 50 years. It's long for us. It's not, it's short in terms of, it concerns my kids. So I think a lot of change will come from insurance companies and the risk that is being insured. Regarding what Michel said about the tension, damn if you do, damn if you don't for the states, I think it's a matter of the arguments to be made by the parties, and very often I think states are very poor at making certain arguments. But even the old version of ECT has an environmental provision. There's a reference under Article 26.6 to the reference to other international obligations that include the Paris Agreement. There would be a way with the existing tools to make certain proper arguments, even by states, that are not made. And that rejoins what you talk about when you talked about specialist knowledge. I think it would be a lot more basic. I think if anybody, when they get into university, had a 30-hour course prior to getting into university about physics, chemistry, geology, climate science, very basic course, 30 hours, a lot of arguments would be made differently, be it in litigation, being by lawmakers or citizens in general. And that a company could be claiming that a product is carbon neutral, or that they are, as a company, carbon neutral, when one knows a bit of basic physics, and that this would be allowed by the law. I don't know what to say, frankly. Sorry.
You want to comment on that, Michel?
My only comment would be, I agree with you, there's definitely a lot of like third generation treaties, including the ECT, which allows various arguments. There's a lot of treaties that are still in existence, which were signed back in the 1970s, 80s, which just don't provide that situation. So it would only be if you could interpret a state's police powers to be compliant with the Paris Agreement. However, if you take investments that occurred prior to the Paris Agreement, you wouldn't be able to make the same type of arguments on legitimate expectations. So I think, yes, there's a lot of arguments that can be made in respect of that, but I think there is a category of situations requiring the old BITs and investments pre-Paris Agreement that you wouldn't be able to make the same arguments.
Maybe we can take one last question.
I apologize for this. Good afternoon. My name is Annie Harutunian. I am an LLM candidate in Sciences Po Law School in Paris. My question concerns something that already Michel touched on answering the previous question. It's on these conflicting obligations that the states have due to the international law and international human rights law developments, especially during the recent years. On the one hand, and on the other hand, the BITs, especially the older BITs that do not really contain provisions on environment or climate change, to give the opportunity to the arbitral tribunal to interpret the BITs in a wider sense. So my question would be, having this context, how could the arbitral tribunal interpret the BITs, these older BITs, based on the Vienna Convention of the Law of the Treaties, in order not to go beyond its jurisdiction and mandate, and in order to issue actually an enforceable award, especially in the climate-related arbitrations? What would the approach of the arbitral tribunal be in this regard?
So do you mean in relation to the tribunal making a decision that's for the state, an anti-investor? Is that the question?
Yes.
So in the old BITs, I think that the key to that situation would be looking at the point of investment. So if you're looking, and this is all getting a bit technical if you don't understand investment treaty arbitration, but if you look at one of the key obligations, which is known as fair and equitable treatment, a part of that is what the legitimate expectations were for the investor when they were making the investment. So if you have an investment which was post the Paris Agreement, you would try and argue that it was within the state's sovereign ability to regulate in accordance with its existing agreements, which would be under the Paris Agreement, and therefore that would fall within what's known as a state's police power, so their ability to regulate in the best interests of the population. So that would be how if I were representing a state, I would make that argument.
Thank you for your question. So I think we can, last one, okay? No, if you agree, last one, and then we continue the discussion over a drink.
I'm sorry, we had one previous
we have a
question
queue.
here. Yeah, so, or maybe we can continue with the
Yes,
questions during the coffee break. I don't know.
We continue during the coffee break, as I'm sure some of you have other commitments. So thank you a lot for attending the event, and thanks to our panelists today.